get started here. So, Fenwick and West, we are a technology-focused law firm. We have a general practice that is really a one-stop shop for technology startup companies. So we're talking about IP today, but our firm has a great corporate practice for helping companies raise money or corporate formation, things like that. We have a tax practice. We have a great litigation practice as well. We were one of the first technology law firms in the world and one of the biggest firms in the U.S. And we have offices throughout the United States. We're headquartered in Silicon Valley. We have offices in New York and Seattle. And we have people like myself spread in other places throughout the country, like here in Austin. These are just some of the companies that we represent. So many of the names up here are large companies because they're recognizable. Many of these companies we worked with when they were small startups, and we continue to work with small startups today that will be on one of these slides in the future. Fenwick is regarded as a top-tier patent practice as well as top-tier IP practice generally. And these are just some of the examples of the recognition that the firm has received. And a little bit about myself. So I've been practicing for over 10 years. I started my career in Silicon Valley and spent about 10 years out there focusing my practice primarily on patent strategy and counseling with emphasis on technology startup companies. My background is in electro and computer engineering, so most of my clients are electronics, hardware, and software type companies. And I've been in Austin since 2015. Love being in Austin, really happy to be here, and happy to connect with people in the startup world in Austin. I love Austin so much. This is me on the weekends after completing my transformation from a Silicon Valley resident to a Texan. Still working on the accent though. Okay, so here's what we're planning to talk about today. I want to give an overview of the different forms of IP that are primarily relevant to startup companies, and that's going to include copyright, trademark, trade secret, and patents. On the patent side, we'll go into a little bit more depth on the second part of the presentation to cover that in a little bit more detail because patents are the strongest form of IP for tech companies. They also tend to be the most complex and typically get the most questions in that area. It also happens to be my area of expertise, so I'd rather spend more time talking about something that I know well. So this is kind of a quick cheat sheet to help get straight what the differences are between the different forms of IP, right? And we have trade secrets. So when we're talking about trade secrets, think about it as protecting your company's secrets. So anything that's confidential, internal processes, it can be technology that is not visible to the public, but this is a legal protection for things that are secrets to your company. Trademarks, think about trademark as something that protects your brand. It is your company name, your logos, slogans, things that someone would affiliate with your company brand and that you will want to protect because you don't want somebody capitalizing on your success. Copyright is something that covers what we call creative works. So think about books, art, media, movies, any sort of creative work that is fixed in some sort of tangible medium is covered by copyright law. I'm going to have slides for each of these, but this is just a cheat sheet. And then patents, think about patents as covering your company's invention. So this is the strongest form of protection for technology that your company develops. Okay, so I'll go through each of these in a little bit more detail and then give you just a couple strategy takeaways for each of them. Happy to answer any questions, but my intention is to run through copyrights, trademarks, and trade secrets relatively quickly, and then spend time talking more about patents in more detail. So copyright. Copyright is a grant to the creator of an original creative work, and it gives you an exclusive legal right to control copying of that work by other people, and it's for a limited period of time, so it doesn't last forever. Again, think about this as you've written a book, you've done some other writing, an article that can be published, you've created a piece of art, a movie, the content of your website can fall under copyright protection. And for technology companies, your computer code itself could actually fall under copyright protection for software companies. What's important here is to infringe those rights, you have to have something actually be copied. So it only protects you against somebody copying your work, meaning it does not protect you against somebody who independently, without any knowledge of what you've done, came up with something very similar. So there has to be some actual copying of the work. What's good about copyright and what makes it fairly simple, and why we typically don't spend a lot of time talking about it with technology companies, is that the copyrights attach pretty much automatically. Once you have created a work and you've put it into some tangible form, so you've published your website or you've put a movie out there, you automatically own that copyright. You don't have to do anything to own that right. There is a copyright registration process, and it is not required for you to own that right. It is required for you to assert that right. So you own the copyright, but before you can take any legal action, if you are actually going to sue somebody for copyright infringement, it is a prerequisite that then you go and register it before you can take that action. There are a number of limitations and exceptions to copyrights, and not everything is copyrightable. I'm not going to go into all of those today, but you should be aware of them. So just some takeaways when thinking about strategy, and again, I'm presuming we're talking about technology startup companies here. For the most part, technology startup companies don't have to worry too much about registering copyrights. The time when you would consider doing it is for visible works that you actually have some intention to license or sell to somebody. If you've created something and you're planning on licensing it, maybe it's a manual or an instructional video or something like that is relevant to your technology company, then you may want to consider registering it. Or if you think it's something that somebody else may actually copy from you and want to sell. Your company website, for example, it's probably pretty unlikely that there's going to be commercial value to somebody else to copying the website talking about your technology company. So it's kind of a scenario where we typically don't have to worry about registration too much. What you do need to worry about as a technology company, or really any company, is know that these rights exist and be very careful about infringing other people's rights. So where this comes into play quite frequently is, somebody grabbing an image off of the internet or a video off of YouTube and putting it on their website as something that's relevant to the company. You have to be very careful about doing that, and you are quite likely infringing somebody's copyright if you do that. So know that these rights exist, and be careful about putting anything on your website, anything in packaging or product if you have a physical product, or anything that you're putting in printed content that could be somebody else's original creative work that they likely have copyright to. The last category is there are some companies that have a system that by its nature is, where you are in the business of distributing content. And this could be, like a sharing platform, right? This is the old Napster case where the platform enables users to provide content that can then be distributed to others, and you as a company may not be directly taking and distributing content, but you are providing a platform that enables others to do that. And if that's part of your business, then you have to be very careful about how you go about that, and ensure that you're taking the right steps. And this falls under what's called the DMCA. I'm not going to go into details of that today, but if your company happens to be focused in that area, it's something that you should become familiar with as to how you can run a platform like that in a way that is going to keep you out of trouble. Okay. Does anyone have any questions? Yes?
If we email you, will you provide these slides?
Yes.
Sweet, thank you.
Okay. We're going to move to trademark. So again, think of trademark as protecting your brand. So this is an exclusive right that you have to use a particular mark that identifies a product or a service. Examples here would be your company name, a logo, a slogan. All of these examples that are shown on the slides are things that would fall under the category of trademark protection. Like copyright, the trademark rights attach by virtue of you using that mark commercially. So you don't have to register the trademark in order for you to own those rights. Once you decide this is my company name, I'm going to start branding my materials and products with it. That commercial use of that mark gives you trademark rights. Again, if you want to enforce it, though, you have to register the mark. And when you register the mark, it's going to go through a process at the Patent and Trademark Office where they're going to make sure that you are the first user of that particular mark within the context that your business is operating in. And that context can be relating to the type of company that you are, what products and services you're offering, and it can also be related to geography. So if there is a company in a totally different business on the other side of the country, that likely will not prevent you from using that mark. But if there is a competitor or a company working in a similar, offering similar products and services that has a similar mark and there's overlap in geography, then you're likely going to run into trademark issues there. So trademarks actually have to be enforced for them to remain valid over a a long period of time. If the mark is not uniquely associated with your company and your brand, then it no longer has validity as a trademark. And if you do not enforce marks and prevent others from using them in a way that is not associated with your brand, then over time you lose your rights. It becomes generic. And to try to make this more clear, some explicit examples of this, think of Kleenex, Band-Aid, jet ski, aspirin. Like, these were all things that at one time were actually a specific product from a specific company. But today they tend to just be used generically, right? Nobody says something other than Band-Aid for Band-Aid, right? But at one time this was, I don't know what company it was, but some specific company said, this is our product, this is our name. Now it's just used generically, and they no longer have the rights to enforce that. So some strategy takeaways when thinking about trademarks. Your company name is typically the most important mark that you will have. And when you're thinking about a company name, you want to generally choose a name that is distinctive. And what distinctive means in trademark is something that will be uniquely associated with your company. And there is a spectrum in the legal world of distinctiveness. The more distinct the name is, the easier it is to enforce that trademark. The less distinct it is, the harder it is to enforce. So just to give some concrete examples here, at the very far end of the spectrum is what the legal world calls a fanciful trademark. And that means that it's effectively a made-up word that you've come up with that really has nothing inherently that ties it to the company, right? So if you think about Xerox or Exxon, it's not immediately apparent why those names reflect copying machines or oil and gas, right? It's a new, unique term that is not particularly associated with the product or services, and that makes it a very strong mark. At the next level down is what we call arbitrary. So that's terms that exist, but it's arbitrarily associated with the products or services that you're offering. So you think about Apple, right? If Apple was selling apples, it would not be a good company name, and it would have no trademark protection. It would be generic. But because Apple is selling computers, it's pretty arbitrary choice of a name, and that makes it a fairly strong mark. The next level, you have what we call suggestive. So that is something that is not directly descriptive, but is suggestive of the products and services. So if you think about Microsoft, right, they're working with software, so you have soft and you have micro, which suggests microprocessors and other related technologies. When you hear Microsoft, it sounds like a software company, but it's not necessarily descriptive of a software company. So that's what suggestive means. And at the lower end of the spectrum, you have marks that are merely descriptive. So like Raisin Bran, right? It's literally describing the product. That makes it a difficult mark to enforce. Or Park and Fly, right? It's directly descriptive of what the services that they're offering is. And at the very low end, you have generic, which are basically going to be unenforceable. Right? If you own a grocery store and you just call it grocery store, you're not going to be able to prevent anybody else from opening an identical store with also a grocery store right next door. So this is something to think about as you're coming up with a company name, and if you want your brand to be really strong, you should look towards the upper end of that spectrum. So ideally for startup companies, ideally you want to register a trademark, at least for the company name, as early as you know that that name is going to be permanent and fixed with the company. The reason to register the trademark early on, again, you don't need to register it in order to own the trademark, but the better reason to register it early on is because you'll know that that is available to you. So by the process of registration, the Patent and Trademark Office will do a search, and they will only let you register that trademark if it is available because it's not being used by somebody else in the way that you are proposing. So even if you don't go as far as to register it, I always recommend at least trying to determine that that mark is actually available to you before you start using it commercially. And it's much easier to do that early on than it is to do it later. So at the early stages of your company, it's, especially if you're, in stealth mode, you're not selling products, it's not that big of a deal to rebrand the company if you have to, because that mark is not available. Later in the company, if you're selling the product and you've been using the mark for a long time, it can be it's a big deal and a huge headache to realize that you may be infringing someone else's trademark, and then you potentially have to rebrand the entire company. Yes?
Just a question on the arbitrary, because a lot of startup companies tend to choose words that have nothing to do with their actual business.
Yeah.
So how much overlap is allowed? So if I want to call my blue bank, someone out here wants to be blue yachts, and someone else wants to be blue sky.
Right.
I mean, how much overlap is allowed for those generic kind of arbitrary words?
So it's a case-by-case legal question, and the legal standard as to what infringes is whether there is a likelihood of confusion, right? So if, depending on the geographic area and the types of services that you're offering and how the companies are using the marks, if a court will look at all of that and they will decide, are customers going to be likely to be confused into thinking that one company is the other, and in that case, there's likely liability for trademark infringement. And in the case of a conflict like that, it's the first to use the mark is the one that is entitled to it. This scale is so you are less likely to run into that problem if you're using a fanciful mark than if you are using a descriptive mark. Okay, any other questions? Okay, so quickly on trade secrets. Again, trade secrets are protecting against what we call misappropriation of secret information. And it's information that confers some economic benefit to the company. So examples of this would be your technical know-how. It could be internal processes that you use. It could be formulas, things like that you are keeping secret and that are providing some benefit to your company. Trade secret protection only protects against misappropriation, which effectively means someone's stealing that secret information. It does not protect against somebody independently developing it. So, or somebody reverse engineering it, right? So someone, if you have a physical product and someone can get a hold of it and they can reverse engineer it and figure out how it works, that is not considered trade secret misappropriation. That's fair game. This is talking about someone breaking into your company and stealing prototypes from your desk or stealing code from your computer. that's the less likely scenario. It more often comes up in the context of employees moving between companies, and an employee having something that they developed at one company that is belonged by the company and is trade secret information of that company, and that employee then moving over to another company and taking that technology with them. Okay. So just some strategy considerations to keep in mind. The most important thing about trade secret protection and in order to maintain that legal protection is that you have to keep it secret. And that means you have to take reasonable precautions internal to your company to maintain secrecy. Your employees should know what things are confidential to your company, and you should take reasonable safeguards to maintain that secrecy. And then you have to be very careful with employees moving around, and this goes both ways, right? Employees coming into your company, you want to make sure that you're not actually taking someone else's trade secrets by having an employee come over and bring with them things that they took from their prior company. And when we talk about importing trade secrets, right, we're not talking about a person's general expertise. Everybody is allowed to use their expertise for different employees. We're talking about taking software code off of the computer from your former employer and directly importing that into software code for your new employee. So we're talking about things like that. There can be a lot of gray areas there, obviously, as to what is actually trade secret misappropriation and what is simply having expertise in an area. And the other thing to think about with trade secrets is, we'll talk about this a little bit later, but there's very often trade-offs between what your company decides to keep as trade secret versus what you try to patent. And when you patent something, if the patent is granted, it becomes public. So you are, in exchange for those patent rights, which we'll talk about later, you are revealing to the world what your technical solution is. So before you go down that path, this is always a trade-off to think about, is this something that we could instead maintain a trade secret, and which is the better form of protection for the company? Because for the same piece of technology, you cannot have both. If it's patented, then it's public, it's not protected by trade secret. And if it's trade secret, then you've chosen not to reveal it, in which case you will not get the patent on. So it's one or the other in that case. All right, any questions? Yep.
What are the typical documents that you execute with employees with regards to trade secrets?
So it's typically something that would be included as part of a employment agreement. So, a standard employment agreement would include clauses relating to confidentiality and assignment of IP rights. And the confidentiality aspect of it is something that you want in there to protect your trade secrets. Some employment agreements will also have clauses about having the employee make a representation that they are not importing confidential information from their prior employer, and that's to provide the company with some protection against things that an incoming employee may do that the company is not aware of, right? So the company gets sued for trade secret infringement and you just point your finger at you're a bad employee.
Can you give examples of companies that sort of were at crossroad and decided to keep it secret versus going for patent protection, and what considerations they said this is why we're going to do it? Some examples.
Yeah, it happens all the time. So it's actually very common discussion that I have with my clients. There are some situations where it makes where trade secret is not actually available, and then it's not the right conversation to have. So again, remember, trade secret has to be something that is secret. So if the product that you're talking about is something that you are selling and it's going to be visible, and the features that you're talking about are going to be visible to the world, then really the only form of protection you can be talking about is patent protection. You can't protect it by trade secret because you're going to be showing it to the world. It typically comes up in the context of technology that is working behind the scenes. So this could be software code. So it could be, you have an artificial intelligence back engine that's doing something that, the user sees a result, but the user doesn't know what the algorithm is that's happening. So maybe you came up with a really great new face recognition algorithm, right? And the user will just see that the output and the face recognition result, but they won't know what the algorithm is. And you could choose to either try to patent that algorithm, or you could decide, rather than try to patent it, I'm just going to keep it secret. Another example can be internal manufacturing processes. So if you're manufacturing something and maybe there's some innovation in how you're doing that process, but the public will never actually see that process unless you file a patent for it. They will just see the end product. So, the trade-offs to consider is one, cost. It costs you basically nothing to keep it as trade secret, and it costs you quite a bit to try to patent it. So that's a big trade-off. On the other hand, patent protection is a much stronger form of protection, because if you just keep it as trade secret, another company can reverse engineer it, they can come up with it on their own, and you have no recourse against that, whereas with a patent, you do.
The other question, similar to this, would be, let's say that there's a process for example, 6 or 7 steps, right? Steps before it's biocritical, that they're not straightforward, difficult to deliver, and there's a finished product, right? So the company A decides to keep it a trade secret, others are reviewed, but those critical steps are not reviewed. And the company B comes up, does iterations, permutation combinations, and comes up with a process almost similar or identical to company A, and decides to patent this whole chain now, right? The whole process. So what happens then? Now it's out in the domain, the output is similar to what the company A was producing. They decided not to seek for patent protection.
Yeah, so the question is, I think the question you're asking is, you decided to maintain your process secret, and then somebody else later tries to patent it.
Right, part of it, not the whole thing, of course, and now this company comes in, does the whole process
Right.
as a patent, right? So you decided to keep some part secret, which you thought was a key sauce, which people can't figure out. And
Yeah.
So what happens in those situations?
That's right. So patent rights are based on first to file. So the first person to file, if 2 different entities come up with the same or similar invention, the first to file it is the one that is able to obtain the patent. That being said, there are some, in certain situations, there are ways to avoid your company being liable for infringement under what's called prior use. So if you were using the technique commercially prior to the other company filing for the patent, it doesn't give you the rights of the patent, but you can avoid liability for infringing their patent based on that prior use. Yeah.
And when you say prior use commercially, does that mean that you have to be selling a product at that point, or does that mean public exposure?
It doesn't mean public exposure.
Okay.
And it doesn't necessarily mean selling a product, it just means you've been using it for business purposes.
Okay.
Don't you have a pretty good case to validate their patent if you want to at that point?
So it's an interesting question, but if what you were doing is entirely secret, and not available to the public. Under the first to file rules, the patent can only be invalidated by publicly available information. So you actually cannot, if it was kept entirely secret, but your company can potentially avoid infringement, although others can't. Okay, so we're going to talk about patents now. So a patent is it's a set of exclusive rights. It's granted to an inventor of something that is new, useful, and non-obvious, right? And this can be a machine, it can be a process, it can be an article of manufacture, it can be a composition of matter. Think of this as technology, right? So this is functional elements as opposed to trademark, which is brand, or copyright, which is the creative works. These are functional elements of hardware, so it could be circuits, it could be touchscreen devices, it can be consumer products, it can be software or mechanical systems, drug formulation, manufacturing processes, kind of anything that is considered technology. Talked about this already, but patent is a very strong form of IP protection in the sense that somebody can, if you own a patent to something, even somebody who has no idea that you own that patent came up with the same solution on their own, you can still enforce that patent against them. It does not require that they copied it from you. It does not require that they even knew that you had a patent on this. So this is just to give you an illustration of the types of things that can be patentable. When you think about patenting a product, you're really thinking about patenting an invention as opposed to a specific product, right? So my phone, right? You wouldn't file a patent on a phone. You would file a patent on all of the different innovative aspects of it, and those could all be different patents. So it could be, there may be a patent on the glass, there may be a patent on the processor chip, on the process for manufacturing it, methods of operating it. So a complex product likely has hundreds or thousands of patentable inventions. And when you're thinking about patents, you want to be thinking about inventions rather than necessarily just a product. Okay, very important to keep in mind that patents are an exclusionary right. And what we mean by that is that it gives you the right to stop somebody else from doing the thing that you have patented. But that does not necessarily give you the express right to do the thing that you have a patent on. And an example of this is you may have a patent on whatever this is, some sort of flying car that shoots lasers out of it, and that does not necessarily give you the right to go build and commercialize these things, because I'm assuming that there are laws that say that you cannot fly around cars that are shooting lasers. So the patent does not necessarily give you the right to do the thing that you've invented. It only gives you the right to exclude others from doing it. A more common example of this, and of where this comes up, is this also means that just because you have a patent on something does not mean that you are not infringing somebody else's patent. And to walk you through an example of how that can work, so this is inventor Bob, and let's say Bob invents a stool, right? So Bob invents a stool that has just these components, 3 legs and the seat. And Bob applies for a patent on the stool, and the patent office gives Bob a patent. So Bob now has the exclusive right to make, use, and sell this invention, which is a seat with 3 legs. Okay, so later inventor Jane comes along, and inventor Jane invents a chair. And inventor Jane's chair has a seat, it has a seat back, and it has 4 legs. And she files for a patent on the chair, and the patent office decides that because of the innovative way that she has added a 4th leg and a back that sufficiently distinguishes over Bob's stool and is such a great improvement that the patent office is going to give inventor Jane a patent on the chair. So inventor Jane has a patent on the chair, but that does not necessarily mean that she can actually make and sell this chair, because Bob has a patent on a stool with a seat and 3 legs, and Jane's chair also has a seat and 3 legs and is infringing Bob's patent. So Bob could assert his patent rights to prevent Jane from building the chair, even though Jane has a patent on the chair. So the takeaway here is that when you talk about patentability, it's very important to keep the concept of patentability separate from the concept of patent infringement. Patenting something does not give you the right to do it. And something that's patentable doesn't mean that that you are now clear to do that. You may still be infringing other people's products, or you may still be violating regulations, or there may be other reasons why you are still not entitled to practice that invention. Any questions on that? Yes?
In practice, I'm sure this happens a lot, that's why you're bringing it up, but in practice, does Bob normally want to enter into a license agreement with Jane to allow Jane to use his related patent?
Right, so it depends, right? So Bob might not care if Jane wants to make chairs. Bob may say, I'm in the business of making stools, and I actually think that my customers want stools and not chairs, so I don't care what Jane does. Or Bob may see it as an opportunity and say, that chair's pretty great. I actually would like to make chairs too. And so maybe Bob and Jane cross-license their patents where Jane, can now make her chair because she gets a license to Bob's patent, and Bob can make stools or chairs because he gets a license to Jane's patent. So it can play out in different ways. Yes?
So is this kind of called like patent trolling?
What we in the industry refer to as patent trolls are entities that don't make any product. So there are entities out there that their sole business is acquiring patents, sometimes because they filed them on their own, but more likely because they've bought them from companies that are no longer in business, and then asserting those patent rights against practicing companies. So their sole existence and their sole function is just to sue people for patents, but they're not actually creating anything. So that's what the industry term patent troll refers to. In this case, presuming that Bob is actually in the business of making and using stools, we wouldn't classify it as a patent troll.
I'm asking because there's a patent on an idea, but they don't know how to implement it.
Mm-hmm.
So if someone knows how to implement it, are they able to get around it?
I'm not sure I'm following the question.
So they basically patent the idea, but they don't know how to implement it and make it commercially viable.
Okay.
So if someone else knows how to implement it in a way such that it's viable,
Mm-hmm.
is that?
So yeah, I mean, it's a situation that could practically happen. If you technically should not be able to get a patent on an idea that you do not know how to implement. Part of the requirement for patentability is that you've described the invention in a way that enables somebody to make and use it. And if you don't know how to do that and have not described that, then you should not be entitled to a patent on it. That being said, there are often situations where patents get through that shouldn't, and someone may have some very broad patent to an idea that they don't actually know how to implement it, and that could create problems for someone later who comes along. But technically, they should not be entitled to patent protection unless you actually know how to do that. Yes.
My question is pertaining to the scenario you described. What is the point of a patent system where there's issuance and enforcement at different scopes? Wherein, what's the point of allowing Jane to be issued a patent if it doesn't give her the right to manufacture what she's patented? Because, it overlaps with Bob's. Why not issue the patent because it overlaps with Bob's? Because he could enforce his patent against hers. Is there a point to that?
Well, I mean, we could get into a long discussion about, the policy behind patents, but if you think about it, every innovation is really built on something that existed previously. So the idea would be that Jane is advancing, the world of sitting apparatuses by creating this great improvement from what existed previously. And she should be entitled to exclusive protection for that innovation that she came up with.
But she isn't, because Bob can then enforce his patent against her and stop her from doing so.
So she has the exclusive right to chairs, right? Nobody else in the world can make chairs, or Jane can stop anyone in the world from making chairs.
Right.
She has a problem with commercially because Bob can stop her from making chairs based on his patent. But again,
I digress. I don't understand the point of the system. It just sounds broken. So I think that answers my question.
there is a lot of arguments that there are problems with the patent system, and that's the basis for it. In practice, these things often end with licenses, right? So Jane pays some money to Bob to get a license of the patent, and then she can go make her chairs.
It helps to look at the reverse. If you spent the time, energy, and money to develop a new idea, you want to get paid by selling that idea to customers. And all ideas are based on some previous thing. There's almost nothing that just comes out of existence with no background basis starting point. So you have two options. If you're Jane and you have this cool new seat that has a back that didn't exist before, you either license with Bob, which usually is what happens. But if Bob isn't cooperative or doesn't want to do business for some reason, you wait until his patent expires. You have a limited time for this protection. So Ben Franklin was the originator of this idea that the patent system is supposed to give a limited amount of time for this protection for the inventor. And then it becomes public domain and anybody can use it after the patent expires. So there is a benefit to the public even without compensating the inventor after a certain amount of time.
Right, so, and from Bob's perspective, I invented this tool, and it's not fair that, Jane is now cutting into my business unless she pays me some royalty. Right, so that's how it theoretically should happen. Yes?
Like you mentioned on the trademark side, if you don't enforce your patent when you've become aware of an infringement, do you lose that ability over time?
Generally no, but there are some defenses to infringe. So there's no statutory defense, there's no law that says that you have to enforce it within a particular time period. There are some courts that have kind of this notion of inherent unfairness in somebody having a patent and rather than enforcing it, waiting for a company to grow and grow and grow and grow and grow, and then once they're big enough, then say, okay, now we're going to enforce it. So in certain extreme situations, courts will either reduce damages based on that, or you may be able to avoid damages, but that's kind of the extreme scenarios. But in general, no, you don't have to enforce it in order to maintain the rights. Yes?
What about international? Because obviously this is US based, so what if
Yes.
you were, inventor Bob in the US and there was a inventor Bob in Germany?
Yes, so patents are country by country. So if you have a US patent, you can only enforce it in the US.
Now, what if his patent predates the German one? Does that give him the leg up when he goes into the German market, or does that work typically?
For Bob to have patent protection in Germany, he would have to file a patent in Germany, right? So every company where you want to be able to enforce it, you have to have filed a patent in that country, and it has to be granted in that country for it to be enforceable.
But does the initial, grantment of the patent regardless of location precede another one? So like if he had gotten the patent in the US and someone in China says, oh, I like that, I'm gonna make that,
Right.
file the patent there, gets it, can you overturn that?
Right, so in order to get a patent, and I'll have this on some later slides, it has to be new relative to what was in the public knowledge at the time you filed the patent. So someone in another country who, and that's worldwide, right? So if someone in another country sees, oh, Bob filed this patent, but he didn't file it in my country, that person still would not be able to file a patent because Bob's patent was already in the public domain. It would be considered what we call prior art.
Just a quick follow-up to that about international. Is there any sort of general guidelines as to if I wanted to file internationally, eventually, like say in Europe and then in America, or which way would it be? Is it typically easier to do? If it's going to be the same company filing a patent, would it be easier to start the patent process in America, get it there, and then go to file in Europe? Or would it be easier to go from Europe and then
So you can do it different ways. There's international treaties that basically allow you to get the benefit of patents filed in other countries. And the way that it's typically a one-year deadline. So you could file a patent in the US today. Within 1 year from today, you could file it in other countries around the world, and the filings in the other countries around the world would be as if they happened today. So you get the benefit of having an earlier effective filing date, but the timing of it is early on in the process, right? So you have to make that decision pretty early, and it's going to be before anything is granted and likely before anything is examined that you have to decide. If you don't decide, if you decide not to enter, like if you file a US patent today and in 2 years from now you say I want to file it in Europe, it's too late at that point. So those deadlines come very early on, or you actually lose your rights to file anywhere else. Yeah. Okay, so I'm going to go through these quickly because we're running out of time. I think we talked about a lot of this, just kind of what the requirements are for patentability. The main requirement is that it's novel, which means it's new, and then this requirement of non-obviousness, which is effectively a little bit elevated standard that says it's not good enough for it just be new. It has to be something inventive, and that's something that wouldn't be just some trivial variation. Statutory bar dates is very important. So to protect your rights worldwide, you have to file a patent application prior to any public disclosure of the technology that you want to patent. The US is a major exception in that the US has a 1-year grace period from the date of that disclosure until when you can file a patent application. So if you go public with something today, in the US you'll have 1 year where you can still file a patent application, but if you go public with something today, you've lost your rights outside of the US. So in order to maintain those rights worldwide, you want to file a patent application before anything is disclosed publicly.
And when you talk about public exposure, for example, with like the phone, if you publicly expose, this phone product, but maybe you didn't talk about those patentable aspects of it, would that still be considered public exposure, or would it have to be the things that you're patenting that you expressly say.
Yeah, so it gets complicated, and the laws are different in every country.
Okay.
But generally, outside of the US, you're talking only about things that are actually visible,
Okay.
right? In the US, you have that grace period, but the trade-off is that there is a wider range of things that can be considered a public disclosure. And that includes not just that the technology is published, but it can also include sales or offers to sell a product that embodies that technology, even if you can't see the underlying technology. Okay, I'm going to skip ahead a bit because I wanted to get to some of the strategy discussions. So, why do startup companies get patents? The obvious answer that comes to mind is offensive use, which is that, as we discussed, you can assert a patent and you can prevent competitors from practicing your technology, and you can obtain pretty significant damages for doing that. That being said, most every startup company that we work with has pretty little interest in using their patents offensively. They are not in the business of, they don't want to sue their competitors, and that's not really why they get patents. But of course, that's one thing you can do. More typically, the reason why companies get startups is for what we call defensive use. So it is a deterrent against your competitors from bringing a lawsuit against you, because they will know that if they assert their patents against you, that you're also going to have patents that you can assert against them. Or it can just be a bargaining chip for a cross license, where you're developing technology, your competitors are developing technology, maybe you both want to use each other's IP, and if they are sitting on a pile of patents and you have nothing, you're going to be at a huge disadvantage in that negotiation. Investors, so this depends on the industry, it depends on what investors we're talking about. Number one thing for most startups is finding money, and again, investor dependent, but many times it can be a big factor for an investor as to how they look at valuing the company, or whether it's something that they feel comfortable investing in at all. If they know that you have technology that is proprietary to you, and that if it's a granted patent, that demonstrates that you are an innovative company. Again, it can increase the company's valuation depending on the investor and the industry, and it can be good marketing to be able to label products as patented or patent pending. Again, can act as a deterrent to competitors from thinking that they can copy your products. It can also be used for licensing purposes, if you have technology that you want to license to partners, and as a way of generating royalties. Just to give you an idea, I mean, these are, of course, not always typical examples, but just to show you that these things can be worth quite a lot of money. And these are examples of some judgments that have occurred in patent cases where courts have awarded upwards of $1 billion based on infringement of a single patent. Okay, a couple more slides here to give you some takeaways on patent strategy considerations and some of the typical errors that we can see when it comes to patent strategy. First error, focusing solely on what is most patentable when thinking about trying to patent your technology. Of course, you only want to file patents on things that are patentable, but that is not necessarily reason enough to file patents. So we always want to be thinking about, well, what value is this actually going to be providing to the company to have this patent? And you may have come up with a really interesting, cool idea that doesn't necessarily mean that you should file a patent on it, It just depends on you know, really think about what it is, what value is it going to add to the company. Is it something that I should be considered kept as trade secret? So you always want to be thinking about that value question and not just think that because I have something patentable, I should necessarily patent it. Number two, mentioned this earlier, but when we're thinking about patents, it's not necessarily a product that you're patenting, it's an invention. And what you should be thinking about is, what are the technical problems that I faced when trying to create this product, and how did I solve them? So that will tell you, what are the critical building blocks that required some technical solution. And that's typically where the patents lie. It's not necessarily the high-level product. It could be just one critical component of that product, or it could be several critical components of the product that are each separate patents. And then number three, we always want to think about is the technology that's important to me. Is this something that others are going to see? In which case it's going to increase the value of patenting that, as opposed to something that's completely under the hood that may be better left as trade secret. So if you have a patent on something that is entirely invisible, it's very difficult for you to assert that against any competitors, because you'll actually have no idea if they are implementing that technology or not. So the most valuable patents are going to be things where, if you think about, if my competitor was practicing this technology, would I have a way of detecting that? And if the answer is no, I would have no idea if they're doing this or not, then it's not going to be very valuable of a patent. There are situations where maybe you still want the patent for other reasons, but the most valuable patents are going to be the ones where, if my competitor is doing this, I'm going to be able to know that they're doing it. Okay, and then here's just my recommended approach to how to think about patents. Identify the technical problems that you had to develop a solution for as a building block for whatever it is that your company is doing. So think about what challenges you faced. And then think about what were the building blocks that solve that problem and that are going to give you some sort of competitive edge. Those are going to be the valuable patents that your company may have. Obviously, it has to meet some minimum threshold of patentability in order to get the patent, so you want to make sure that you meet that threshold. But there's no such thing as more patentable or less patentable. It's either patentable or it's not. So you may want to, if you have two things that are across that line where it's likely patentable, focusing on the ones that's going to provide better value, that's going to cover the technology that's giving you that competitive edge is where you want to focus. And then think about how others might circumvent your patent. And think about what are the alternative problems or the alternative solutions to the problems that you've solved. And you can potentially patent those alternative solutions as well. So it doesn't necessarily have to be something that your company is actually doing. It could be, we're doing it this way, but we thought about 3 other ways of doing it that we're not going to implement, but we think that they would be reasonable alternatives for our competitors to do. And you can actually take a strategy of patenting all of those. You don't have to be doing it in order to patent it. And that's going to put up a whole bunch of extra roadblocks for your competitors. On the other hand, if it's, we're doing it this way, and there's 100 other ways of doing this that are all equally viable, that's a reason to think that maybe this thing is not worth patenting, because what is it actually going to stop your competitors from doing? Okay, and that's the end of the slides. I'm happy to answer any questions or stick around and talk afterwards. No questions. Okay, thank you all for coming, and feel free to come up and ask any questions or just come by and say hi. Thank you all.
I always find whenever I meet an employer, it's like the residual knowledge versus the trade secret.
Right.
It's always a great area.
Yeah.
Especially if you were driving like engineering, you know, you help drive architecture and processes and.
Yeah, I mean, the easiest place to draw the line, you know, which, the lines are always fuzzy, but the easiest place to draw the line is just don't take anything with you.
Yeah.
So don't take computer code, don't take
Documents.
schematics, don't take
Yeah.
documents.
Yeah.
And whatever you have in your head is, you know,
Visual
much
knowledge.
harder for somebody to say is not fair game.
Yeah.
And than taking something with you. It's usually when you take something with you is when you get into trouble.
Yeah. I never do that, but it's always here, so, especially if you don't all the diagrams.
Right.
Okay,
Right.
cool, thank you, nice to meet you.
Yeah, thank you for coming.
Mr. Jason, I'm still John.
I think,
Hey, I own a patent, the handy sander, it's a glove that has carborundum and silicon nitride bonded to the outside, okay?
okay, cool.
I had it on the shelves, a company named Norton stepped on me, and they got away with it. Now, is there a magic number, the 4% change, and they're not stepping on your toes?
What do you mean by 4%?
Because, I don't know, it's, that number stuck in my head somehow. Because they did not step, they did not squash my patent, they went around it. And
Okay.
they changed the design up a little bit.
Mhm.
One was a mitt, and then they put like a little thumb on it.
Yeah, okay. So the patent, I mean, your patent covers something very specific. So there's a section, has the patent been granted?
Yeah.
Okay, so there's a section called the claims, right? Are you familiar with that?
No.
Okay, so go look at your patent.
Yeah.
There's a section called the claims. The claims are the legal description of the boundaries of the invention.
Oh, yeah, I get it on my phone.
Okay, so the claims will tell you, you know, it's like a deed for a plot of land, right? That tells you exactly, this is where my piece of land is and this is where my neighbors are. It's like a survey, right? So
I
it
can
will
picture
tell, it describes specifically, this is what my patent covers. And the test that you would be looking at would be, it will list a number of elements. In order for someone to infringe that, they have to do every single one of those elements. It doesn't matter what they do in addition to it. It's, do they do, you know, if you list elements A, B, and C, if somebody is doing A, B, and C exactly as you described it, then they're infringing your patent. So that would be the first thing to look at.
Now, another thing is there a department in mega corporations that looks at patents that are coming down the assembly line for the United States Patent and Trade Office and say, okay, this looks like ours, and let's change it up a little bit and put it on the shelf?
So
Companies do that, though.
not all companies and not across the board, but certainly in certain areas and certain companies, they are monitoring patents that are out there and making sure that they don't infringe it by saying, we're not going to design the product that way, we're going to do it this way. So,
It's a vicious world.
well, thank you, it's nice to meet you, thank you for coming.
Hi, thanks. Thanks for the talk. So I was wondering, for your office hour, is that how is that treated? Is it kind of like a consultation or?
Yeah, so it's through union for Capital Factory members, and it's 30-minute.
I don't know what kind of questions, fair game or whatever.
Oh, so
It was like an API
yeah, so
plugin, like a strike type thing.
so you should not. We shouldn't talk about things that are very specific to your company, meaning information that you would consider to be confidential information. Like, I don't want to talk about, specific, like, here's my algorithm and is this patentable? Because I cannot do that unless we are in a formal attorney-client relationship.
Yeah.
And it's really for your protection, because you're protected, any communications with your attorney are protected, right? They don't count as public disclosures. But in that situation, it's a lot rare. And I also have to be careful about, if you tell me like, here's this really great algorithm I invented, and I happen to have a client that's right in that area, then it becomes a problem.
I understand. Yeah.
So, but most of the time, what we do is we'll just, kind of talk about questions of the law. What are the requirements? Like, how do I do this kind of general strategy? And just kind of not go into specific like technical details.
Cool. All right. Thank you for your time.
Yeah, thank you. Nice to meet you.
Hey, I'm Seth. Enjoyed
Jason.
the talk. That was great. This is my card. I'm a Capital Factory member. So I have a virtual CISO, Chief Information Security Officer, consultancy that I'm in. And, I'm encountering some friction in signing agreements wherein, the way it's structured is such that, the services I'm providing in the form of policies and a program are the intellectual property of my company that they're given like an infinite license to use internally, but not for them to sell. So it's like, hey, don't compete with me, and I'm not doing this for you to compete with me. And also, I need to preserve that intellectual property so I can do the same with every other client. So I can't build you a security policy and then you go sue other clients and say, because they're similar, because they're mostly similar.
Right.
And so I just wanted to gauge your thoughts on that.
So you're working for different companies as a consultant.
Yeah.
And you're asking about what's.
It's like I'm licensing policies almost like you would license software.
Okay.
So,
And you own that?
yeah, that's what's in the agreement, but there's always friction over it sometimes.
Right.
So.
It's just part of the negotiation. I don't think there's a standard process. Typically, a company that's hiring a consultant expects that anything that's developed in the course of that consultancy relationship is going to be owned by the company.
Right.
But things that you have that, coming into that relationship beforehand, I think seems like a reasonable and fair game to say that that's your process and that you own that. And
I need to look at how the big consultancy firms operate, but I assume they have to operate that way because they have templates and they kind of customize them for a client. They sell the same thing over and over again. You can't have all those clients suing each other over who owns it.
Yeah, I think that's right. It's just a matter of getting it in a written agreement to make sure that there's.
Yeah, I mostly got it there. Okay, well, look, good to meet you.
Yeah,
let me check you out with office hours.
Definitely.
Feel free to reach out to me on LinkedIn or via email so we can be in touch.
Yeah, great. Thank you.
Thank you very much for speaking. Appreciate it.
Yeah,
I like
thank you. Oh, good. Okay. Thank you for coming.
Yeah, absolutely. I just have one question.
Sure.
Do you have any recommendations for, like a small startup that doesn't have a ton of current funds, but patenting is something I'm thinking about pursuing? I'm just not really sure what I can do at this point because I obviously don't have a ton of money, and I know that patenting just requires showing it all this stuff. So.
Yeah. So a couple things that I will tell really early companies. One, there were some slides in there that I kind of skipped over towards the end, but the stuff I talked about related to the statutory deadlines and public disclosures. So number one thing is, until you're funded and until you can file a patent application, just be very careful about any public disclosure. Right? So as long as it's not publicly disclosed, you still will have the rights later to file a patent. So that's the number one thing to be really careful about. Number two, you can file what's called a provisional patent application.
Okay, I've heard of that. Yeah.
And it's something that,
buys you a year or something?
It buys you a year, and you have to be very careful with it. It's not something that it's not ideal in the sense that, if you don't do it correctly, then you actually get nothing.
Oh, interesting.
And it can give you a very false sense of security, and that's really the thing to be careful about. If you understand that you may, that if you understand that there's a high risk that, this may not be done correctly and I may actually be getting nothing for this, and you are still, maintain the vigilance about public disclosures and don't actually rely on it, then I think it's generally better to file something than nothing.
Okay.
And if that's what your company,
So if you file it, make sure it gets accepted, or do a really good, put a lot of effort to making sure that it's.
well, what I'm
there's a
saying
higher
is,
probability of-
what I'm saying is, to the extent possible, continue to operate as if you just have
Sure, yeah.
a patent application filed, unless you're very confident that it's,
Right, and the degree of failure is high.
the risk is very high. But if you are going to continue to operate, with, and keep everything.
It's like better than
wraps,
nothing. It's
then-
not better than the application, but it's better than nothing.
Right. And if you do it by yourself, take the time to understand, the requirements. Right, so the requirements that you care about for provisional applications is what's called written description. And effectively, what you need to know is you need to describe the technology completely.
Yeah.
Right, so the misconception about provisional applications is that you can just file anything, get a filing date, and then.
You gotta have the right words describing it the right way, specifically enough.
The nice thing about a provisional application is it does not need to be described in any particular legally correct way. It just needs to be described in a way that somebody skilled in your field would understand exactly how to make and use it. So a do-it-yourself provisional, the key is to spend a lot of time on it, describe it really completely, cover all of the things that you think that you might be wanting to have to talk about with other people. You don't need to worry about legal formalities, but you just need to have a very complete technical description, and then you're probably okay. But I would still always recommend, understanding that there are business trade-offs where you might need to talk about stuff for the business. But I would be very cautious and not get a false sense of security that, I filed it for an application, I'm okay, until you have something that, you're in a position where you can work with a skilled patent attorney to make sure that you're in good shape.
Mm-hmm. And then at what point would you say that maybe like a small startup would be ready to begin doing patent stuff? Like what is sort of like the initial maybe amount of money that would be safe to say like, okay, I can start engaging with this, like trying to get a patent?
Yeah, I mean, a budget for getting a patent filed is going to be $10,000 to $15,000.
Gotcha.
You can do provisional applications less expensive, and that can range anywhere from the $0 do-it-yourself to close to the full cost. And most attorneys will do. It's kind of a range where the more you spend, the more your risk is going to be reduced.
Yeah.
But you can spend very little, and your risk is going to be higher because it's basically like how much of the work are you going to do, and how much is the patent attorney going to be able to do to make sure that things are in really good shape. But kind of the full a full patent application, you're looking at 10 to 15K, sometimes higher depending on the technology area.
Okay, gotcha, cool. And then one other sort of thought, question. From what I'm hearing from you, it sounds like getting the patent is probably one of the biggest protectors. Like you don't necessarily. It sounds like you're saying don't publicly disclose it. As a small startup, in my head, I'm sort of like I just want to I have this thing done and I want to get it to market as quick as I can, but I don't have a ton of funding. So I could go out and try to get a bunch of funding and patent it. But then part of my thought is, let me just try to put this out as quick as I can, bring in some money and get a patent. But that almost sounds like it's like a very unsafe option.
Well, it's not the ideal option, but it's the option. It's a situation that is